Welcome to today's MASB webinar. I'm Stacy Bogard, Assistant Director for Communications and Public Relations, and with me is someone who needs little introduction for most of our audience, our Legal Counsel and Director of Labor Relations and Policy, Brad Banasik. How are you today, Brad?
I'm doing great, Stacy. How are you?
I am doing fine as well. Today we're going to go through some of the questions and scenarios that you've been fielding since the start of the COVID-19 pandemic, particularly those regarding the Open Meetings Act, virtual meetings, the Freedom of Information Act, personnel, and student discipline. Let's jump into our first question about OMA and virtual meetings. A day or two prior to our scheduled virtual meeting, we are planning to connect all board members virtually for a few minutes for the sole purpose of resolving any connection issues we may have and to familiarize board members with how to communicate in this fashion. Do we need to post this event as a meeting and make provision for public comment?
Well, first of all, it's a great idea to have a test or a practice meeting. Obviously, school boards haven't conducted virtual meetings in the past, so this is a new practice for school boards. So you want to make sure that everything is going to run correctly, and having a dry run meeting is a good way to do that. And it doesn't have to be posted under the Open Meetings Act, and you don't have to comply with the executive order that allows for virtual meetings as well, meaning that if you have this practice meeting, the community doesn't have to be a part of it. You don't have to allow that community participation. The key is keeping that meeting purely social. The Open Meetings Act has an exception that allows for social gatherings that don't have to be posted as meetings under the Open Meetings Act, so those social gatherings aren't covered by the definition of a meeting under the Open Meetings Act, which is board members getting together to deliberate on matters or make decisions on issues relating to the school board. So while a school board is having that test practice meeting, maybe they should just get caught up on what other board members are doing in their personal lives and steer away from any school district discussions during that practice meeting and save that for the scheduled virtual meeting.
By law, we are only required to have one school board meeting a month, correct? But if we regularly have two board meetings a month, what is the best practice for canceling a meeting?
So it is correct that a school board must have a monthly meeting. That's required by Section 11A of the school code. However, that requirement is currently suspended by an executive order. That order is going to expire April 15th. We're expecting that order, which it allows for virtual meetings, to be extended, but not entirely positive that the monthly meeting requirement will be suspended as well. So we're kind of waiting to see what that order is going to look like once it's extended. So technically, as of right now, you're not required to have a monthly meeting. But if a board has had two monthly meetings and wishes to cancel one, there isn't a process under the Open Meetings Act for canceling a meeting. My best practice recommendation is you get as much notice out there as possible that has been canceled. So obviously you would post notice on your website that the meeting has been canceled. You would post the paper notice at the location of where the meeting was going to take place to let folks know that it was canceled, and any other means of communicating to your public that that meeting is no longer going to be held.
We don't have a meeting until April 20th. Should we plan, from what you are hearing, to hold this meeting virtually?
I think so. At this point, I think it's likely that the stay-at-home order will be extended, and I think for the foreseeable future, school boards will have to conduct their meetings virtually.
Can we provide the public with an email address to send in their comments prior to the meeting, and then we would read these during public comment instead of having the public address the board during the meeting?
It's an interesting question because the executive order that allows for virtual meetings does make reference to allowing community members to submit comments in writings that may be read at the board meeting or may be communicated to board members. However, I don't interpret that process to replace the actual public comment. So I think you can encourage board members, or excuse me, community members to submit written comments to the board that may be read at the virtual meeting, but you cannot require them to do that in place of public comment. So if you're having a virtual meeting, whether it be by video conferencing or a telephonic meeting, at some point in that meeting, you're going to have to allow your community members to address the board during the meeting. My opinion, submitting comments does not amount to addressing the board. I think it must be a real-time type of situation where a community member is addressing the board in real time during that meeting. What I think you can do, though, is require individuals to sign up ahead of time in order to participate in public comment. To me, that creates a more business-like meeting and avoids any type of disruptions to the meetings where you may have a last-minute participant for public comment. So I suggest that you allow people to sign up for public comment right up until the meeting is called to order, and then you have your list of individuals who are going to be addressing the board, and you can unmute those individuals as you get to the public comment period time of your board meeting.
All right, sounds good. So this one is a two-parter. What if we personally do not have a device or internet? Can we do an in-person proper social distancing at the board office? Additionally, is the operation of a board meeting face-to-face considered essential as it pertains to the executive order from the governor? Are we able to meet in person, keeping in mind social distancing?
Okay, yeah, this is somewhat of a complicated question, and it's based upon interpreting Executive Order 2020-21. That's the stay-at-home order. You know, there's a provision in that order that clearly states, you know, all public gatherings of any number of people occurring among persons not part of a single household are prohibited. So I've interpreted that provision to prohibit an in-person school board meeting. Now that restriction is subject to exceptions found in another part of the order, and it talks that the exceptions relate to governmental activities. But in reading the exceptions, it's not clearly stated that a municipal board, such as a school board, would be exempt from that restriction on public gatherings. Now, there could be an exception if a school board is clearly unable to meet because you don't have access to the internet or you can't have a telephonic meeting. I think that would be extremely rare. Possibly not having the internet access, not so much, but I think you can still have a telephonic meeting by conference call. If you're not able to do that, then I would suggest contacting your district's legal counsel and getting an opinion on whether there is possibly an exception in the executive order that would allow for an in-person board meeting. But I still think the public would have to be excluded from that meeting according to the executive order. So I think if there is an exception, it would be extremely, extremely narrow, and I would only do that if you have a clear written opinion from your attorney saying that yes, there is an exception that allows a board to meet in person for very, very unique and extenuating circumstances. But I'm currently taking the position that the executive order would not allow an in-person meeting, that while that order is in effect, and obviously it's going to be extended, all board meetings must be conducted virtually.
Our Board of Education would prefer not to have their emails posted. Is it okay to just use the superintendent's email?
Well, the executive order indicates that if you're having an electronic meeting, the meeting notice must include a provision indicating how a community member can contact a member of the board. As long as the superintendent, in regard to the question, as long as the superintendent is forwarding all emails to board members, so the board members are receiving that information, receiving the comments from the general public, I think you could do that. It's really no different than posting on the notice one email that goes to all board members. I know some boards will have that type of communication access to board members, where if you just send an email to one address, it goes to 7 members. Kind of the same thing with contacting the superintendent. It would be sent to the superintendent, and then the superintendent would forward the messages on to the 7 board members. So as long as that's what occurs, yeah, I'm okay with that.
If we start a virtual meeting by putting everyone on mute, and then the host of the meeting unmutes when participants raise their hands in the chat feature, is that giving the public the ability to be heard?
So I kind of addressed this question a little bit earlier, but I'll go into more detail on it. And when you administer your public comment and you're doing a virtual meeting, whether you're using Zoom, Google, WebEx, there's a number of different functions that could be used with those programs to administer public comment. However, I do recommend when you're having a virtual meeting is when folks enter the meeting, not your board members, but community members, that they're all on mute. And then have a process that unmutes their microphone when they wish to participate in public comment. Now, I recommended earlier, you have community members sign up in advance. In regard to this question, they're suggesting having the option of raising your hand during the virtual meeting. That's fine as well. That may create a little bit more disorganization as far as administering the public comment, and there's more of a possibility for interlopers into the meeting that may have the intent to disrupt the meeting. We've all read about the Zoom bombing type of situations, and without having folks sign up in advance, I think you're more susceptible to those type of disruptions. So, but under what the individual is asking, I think clearly that could be done, and that would be in compliance with the Open Meetings Act as well as the executive order on virtual meetings.
Are committee meetings with 3 or less board members subject to the requirements of Executive Order 2020-15?
They very well could be. Now, MASB over the years has taken the position, go ahead and post your committee meetings and conduct them in compliance with the Open Meetings Act. It's just easier to do it that way rather than going into the analysis that the courts look at as whether a committee is subject to the Open Meetings Act. Because of the difficulty in conducting a virtual meeting, I'm recommending that boards look at their committees and whether their committees must comply with the Open Meetings Act and thus must comply with the executive order on virtual meetings. The analysis generally states that if a committee is performing a function on behalf of the board, then that committee is a public body for the purposes of the Open Meetings Act. So the board has authorized the committee to act on the board's behalf. Okay, so the committee is now performing a governmental function, and that makes it subject to the Open Meetings Act. If you have that type of situation and your committee is still meeting during this COVID pandemic, then the committee, yes, would be subject to the executive order on virtual meetings and would have to comply with that executive order and would have to allow community participation within that community committee meeting. If the committee is just simply gathering information and is not going to be making a decision on behalf of the board, may just be passing along guidance and information to the full board without any decision making, then that committee is not subject to the Open Meetings Act and wouldn't be subject to the executive order on virtual meetings. And then you could just have a I guess, a private virtual meeting between those committee members. It wouldn't have to be posted, and the public wouldn't have to be involved in that committee meeting.
Okay, so moving on to questions about FOIA and Executive Order 2020-38. Did Executive Order 2020-38 extend the time frame for responding to all FOIA requests?
It only extends the time frames to certain requests, at least the initial section of that executive order. Before the executive order is written, every FOIA request, you have 5 business days to respond to that request. What the executive order has done is that if you receive a FOIA request via U.S. mail, hand delivery, or by facsimile, so it's actually being sent to the physical location of the school district, you now have 10 business days to respond to that FOIA request as soon as it's received. And the executive order defines receipt as the envelope or being physically opened and you're reading the FOIA request, or you're going to the fax machine and you're taking the request off the fax machine. So if that FOIA request remains in the fax machine until schools reopen again, that 10 days is told. It doesn't start until you actually receive that request. But that additional 5-day extension doesn't apply to email FOIA requests, and that's generally how most FOIA requests are received by school districts nowadays, is they're received via email. So if a school district receives an email request, you still only have 5 business days to respond to that request. So I think the assumption is, just like, we're checking our email from home remotely, the FOIA coordinator for the school district is doing the same thing, keeping abreast of all the emails that are coming in, checking to see if there is a FOIA request in an email.
Did the executive order change the definition of what constitutes a business day under FOIA?
It does not. So I referred to that term, and that's the time frame as far as responding to a FOIA request. A business day, as interpreted by an attorney general opinion, is 5 consecutive weekdays. It doesn't matter if the public entity is open for business. So that definition of 5 business days is not suspended while all the school district buildings are closed. Okay, so you only exempt weekends and holidays from calculating the 5 business days. So that has not changed under the executive order. So again, going back to our example, we're receiving a FOIA request via email. If it comes on a Monday, you have and that's day 0. You have until the following Monday to respond to that FOIA request, as long as there are no holidays mixed in to that request.
Are school districts able to extend the time in which they must respond to a request due to COVID-19 orders and regulation?
Yes, I think this is probably the most significant part of the executive order, and it applies to all FOIA requests, not just the FOIA requests that are mailed or hand delivered to a school district or faxed to a school district. Would apply to email FOIA requests as well. So traditionally under FOIA, a school district can state that it's extending the time it's going to respond to that request by 10 business days. So you traditionally have 5 business days to respond. You can extend that to 10 business days. Now, under the executive order, you can go beyond 10 business days to when you're going to respond to that request, and you can extend it all the way to June 4th if necessary, and possibly even further than June 4th if we have another executive order that extends this executive order relating to FOIA deadlines. So going back again to our email hypothetical, you would have to request that extension within 5 business days. So you still have 5 business days to request the extension. Once you request that extension, indicating that you're unable to respond to the FOIA request because of COVID-19 or a regulation related to COVID-19, you can indicate that you will not be granting a denial or granting the request, I should say issuing a denial or granting the request until June 4th in regard to that specific FOIA request.
What if a FOIA request requires in-person efforts, such as an in-person search, inspection, examination, preparation, or production of public records by the requester or school district?
Okay, in this case, the executive order also allows the request to be deferred until June 4th if it requires an in-person inspection. Whether someone the person making the FOIA request wishes to come in and view that record in person. Obviously, under the current stay-at-home order, you can't do that. So that could be extended until June 4th. Or maybe the FOIA request requires a person to come in, research records and redact records that are exempt from FOIA. That would be an in-person effort. If the FOIA request involves that type of situation, then that part of the FOIA request could be deferred as well to June 4th. I'm just kind of summarizing a lot of these requirements. We are going to be posting additional FOIA guidance on our website soon, so that will give you a bit more detailed guidance on how this executive order affects how a school district responds to a FOIA request. So look for that on our website soon.
Moving on to personnel issues, should we pay our spring sports coaches?
I've received this question on a couple of occasions, and it really is going to come down to the collective bargaining agreement. Now, and I'm going to address this question assuming that these are coaches that are teachers, and then I will address the question for the individuals that are not teachers and they're receiving a stipend. So for a coach that is a teacher, and thus they're going to be getting a stipend under the Schedule B part of the collective bargaining agreement, look at the agreement, okay, and see if it addresses situations where a season has to be canceled. Now, obviously, what we're experiencing now is unprecedented, but there have been situations in the past for school districts where they've had to cancel a spring sport. Maybe not enough students went out for the sport, or maybe there was a situation where a number of athletes were suspended and they were unable to field a team, so they had to cancel that particular sport. So collective bargaining agreements will address this. We'll look at your CBA, see if there's language that indicates whether the stipend will be prorated, and whether there's going to be any compensation related to paying that coach. And if your contract is silent, then you may have to rely on past practice. If there has been a cancellation of a sport in the past, follow what you did with that practice, and just do that under the current circumstances. Now, if you don't have specific language or a past practice, then you may have to enter into a letter of agreement with your union, indicating how these folks are going to be, how the coaches are going to be paid, and also that could be part of the continuity of learning plan that's going to be submitted to your ISD, and that would kind of tie into whether you're paying all your staff members, which is required by that plan. So let's also take a look at it from the perspective of individuals who are not teachers and they're just receiving a stipend from the school district district for coaching a spring sport. These folks are exempt from the Fair Labor Standards Act, so you don't have to worry about whether they worked 5 hours, 10 hours, 15 hours prior to the closure of schools. If there was any work that was performed, then you would just prorate what they're going to receive as part of that stipend. So if traditionally, the spring sport season is 20 weeks, or let's say 15 weeks, and maybe they had 2 weeks of practice before the school district closed, you would prorate that stipend accordingly, paying them for 2 weeks of practice.
Should we continue to pay third-party contracted employees?
The executive order doesn't specifically address paying third-party contracted employees. What school districts are going to have to do, if these employees are not going to be performing any services going forward while instruction is occurring remotely, then these individuals are likely not going to be paid. But you need to follow your third-party contract that you entered into with this third-party employer. And if there's any payment that is going to be made, obviously that payment is made to the third-party employer and not the specific employees. Because those employees, they technically don't work for the school district. They're working for the third-party employer. So in this situation, you just follow your contract that covers the relationship between the school district and the third-party employer. And the same thing can be said for vendor contracts as well. If you if you have a contract with a particular vendor and this vendor is providing certain services or equipment to the school district, and you need to suspend that contract, you have to look at the language in the contract to see if it is permitted and follow that language, because unless you have a very specific clause, a force majeure clause that allows the district to get out of a contract because of different forces of nature, epidemics, or whatever the case may be, you're going to be bound by that contract.
What is going to be done about staff and admin evaluations? If teacher and admin evaluations are waived for this year, will the evaluation rating be a blank field in the rep report?
That's a great question. And obviously the executive order has suspended evaluations, administrators and superintendents. What isn't clear at this point is what must be entered in the rep. I've heard, this is just rumors, unsubstantiated rumors, that you would enter last year's evaluation rating. I'm not entirely sure of that. I'm not sure where that rumor came from, but hopefully the Department of Education will issue additional guidance on this. My thought would be that because everything else is suspended, I would think the rep reporting would be suspended as well, so there wouldn't be an obligation to report the evaluation rating to the rep this year, or in the rep this year. But that, again, is just my guess. Hopefully, this will be clarified by the Department of Education in the near future.
Lastly, a few questions about student discipline issues. If a student is expelled for 180 school days, do the closure days we are currently experiencing count towards serving that expulsion period?
I would compare those closure days with vacation days, whether it be spring break or summer break. According to the executive order, those aren't considered to be instructional days. And if they're not instructional days, they likely won't be counted towards a student serving a suspension. But this is going to be a local issue. The executive order really didn't address student discipline issues. There's really nothing out there on student discipline issues. So it's really going to come down to the school district satisfying the due process requirements in carrying out this discipline in regard to the student. So a district could indicate that, yes, the closure days does go towards computing the 180-day suspension, but they're not required to do that. That, in my opinion, is going to be a local decision that should be based upon ensuring that the students' due process rights are protected.
Let's say a student was suspended for 8 school days and only served 4 prior to the current COVID closure. Is the student forced to serve the remaining 4 days at the beginning of the next school year if schools do not resume until then?
So schools are, in fact, resuming, but they're going to do it remotely. I think with this type of suspension, to me, it just makes sense that you would allow any type of suspended student to engage in the instruction remotely, unless it's been a permanent expulsion. When someone is permanently expelled, for possessing a weapon on school property or committing criminal sexual assault on school property, then technically that student is no longer enrolled in the school district. So with that type of student, you're likely not going to include him or her in the remote learning. But all other suspensions, all other expulsions, to me, it would make sense to include those students as part of your remote learning program. The executive order doesn't require that. The template application doesn't make mention of educating suspended or expelled students. But to me, that's just good public policy that you would do that.
If schools end up being closed for the remainder of the year, and some students were suspended or expelled for the remainder of the 2019-2020 school year, instead of being suspended or expelled for a specific number of school days, does that mean their suspension or expulsion ends on the date of the official closure?
Well, again, the way the executive order reads that schools are not closed. We're going to complete the 2019-2020 school year, but we're going to do it remotely. So if a student has been suspended until the end of the 2019-2020 school year, it would be my opinion that suspension ends when the remote learning ends for this particular school year. Now, school districts are given quite a bit of flexibility of what their calendar is going to look like moving forward with their remote learning. But again, I think it makes good public policy sense that a student who is under suspension still receives an education, and at the same time that student is serving the suspension while engaging in that remote learning, and thus the student should be able to restart in-person learning the next school year. Now, again, that's kind of my personal opinion. That's going to be a local decision by school administrators and school boards, but again, a local decision taking in consideration the due process rights of the student.
Well, thank you, Brad, for taking the time to answer these and many other questions. As you mentioned earlier, we do have a couple of FAQ documents on the website along with other resources that you can see at masb.org/COVID-19.
I just want to remind folks that I'm still available for phone calls and emails. And if you have questions that were not addressed during our webinar today or not addressed in the FAQs, definitely call my office number, and it's forwarded to my cell phone. Again, that number is 517-327-5929, or simply send me an email at bbanasik@masb.org. We're going to be here to serve you throughout this entire pandemic, and hope to continue to serve you as we get through it as well. And from my perspective, I would also like to say thank you just to all the medical professionals out there who are working overtime, who are probably seeing things that they never thought they would see when they entered the profession. So I cannot express enough gratitude to those folks, and I just hope that they're able to continue to do what they're doing for us.
Agreed. Thanks, Brad.
Thank you.